Is federal entrapment different from state entrapment? Imagine being accused of a crime you didn't plan to commit, only to find out the government might have pushed you into it. That's what entrapment is all about. It's a defense used when someone claims they were tricked or persuaded by a government agent to do something illegal. Now, the question is, does it matter if the case is in federal court or a state court? The answer is yes, it can make a difference. Entrapment happens when law enforcement or government officials persuade someone to commit a crime they normally wouldn't consider. The goal is to stop law enforcement from creating crimes that wouldn't happen otherwise. There are two main tests courts use to decide if entrapment occurred. The first is called the subjective test, which looks at the defendant's mindset. It asks if the person was already willing or likely to commit the crime before the government got involved. If they weren't predisposed, then entrapment might be claimed. The second is the objective test, which focuses on the government's behavior. It asks if the government's actions were so unfair or extreme that they would cause a normal person to commit the crime, regardless of their original willingness. In federal courts, the law uses the subjective test. This means the defendant has to prove they were not already inclined to commit the crime and that the government's actions caused them to do it. The burden of proof is on the defendant, so they need to show that the government's involvement was the main reason they committed the crime. Federal law does not requiring undercover agents to identify themselves, so the defense often focuses on whether the defendant was predisposed to commit the crime before the government's involvement. Most states also recognize the entrapment defense, but they might use different rules. Many states also use the subjective test, like federal courts. However, some states and the model penal code use the objective test instead. This means they look at whether the government's conduct was improper or unfair, regardless of whether the defendant was predisposed. This can change how the defense is built because the focus shifts from the defendant's mindset to the government's tactics. Practically speaking, the main difference for someone facing charges is knowing which test applies. If it's a federal case or a state that uses the subjective test, the defense must show the person was not predisposed to commit the crime. If the state uses the objective test, the focus is on whether the government's actions were unfair or excessive. Remember, entrapment only applies if a government agent is involved. If a private person tricks someone into committing a crime, the entrapment defense doesn't work. For defense attorneys, understanding which test applies is key. They gather evidence about the defendant's past behavior and the government's conduct. If they can show the defendant had no prior intent, that can help. In states that use the objective test, they might argue the government's tactics were improper, even if the defendant was willing. Even if entrapment isn't a full defense, raising it can influence plea deals or jury decisions. The goal is to show that the government's actions were unfair, or that the defendant was not predisposed to commit the crime. So, in summary, federal and state entrapment laws can differ mainly because of the legal test used. The federal system relies on the defendant's predisposition, while some states also consider whether the government's conduct was improper. Knowing these differences helps build a stronger defense and can make a big difference in the case outcome.